Welcome everyone. This is the second public law webinar in our series. I'm Amanda Jepson and beside me is Carolina Bax. The previous seminars, which are the private law webinar and public law session, can be found on our website and YouTube channel. Carolina, do you want to make a start?
Absolutely. So, good afternoon, everyone, and thank you for joining us today. We're going to start our public law case update with this case that provides new guidance on clarification of reasons. And that stems from an appeal after a fact find that revisited effectively the guidance that applies to seeking clarification of reasons in the aftermath of a decision. Within that Court of Appeal decision, we have a very useful warning about misuse of seeking clarification post-judgment, which is relevant for all practitioners, but particularly aimed here at family practitioners. The facts of the case here are as follows. As I've mentioned, it was an appeal against a fact find, but specifically this was a 14-day fact-finding hearing into injuries against a child. The local authority here was seeking 24 separate findings, and the majority were made. However, after the judgment was handed down, a series of emails were sent by all legal representatives seeking clarification of findings. And in the judgment, alongside those, there was also a position statement submitted to the court further seeking clarification of findings. One of the points made by the local authority was that this clarification process had in fact simply resulted in confusion and inconsistency. And in fact, that meant the integrity of the judgment couldn't be maintained. On that basis, they sought for the judgment to be set aside and for the matter to be reheard. Lord Justice Baker was one of the judges dealing with this appeal and commented that the scope of the clarification exercise here was altogether unreasonable. He calculated there might have been no fewer than 7 separate requests for clarification between July and November. I quote directly from Lord Justice Baker's words in addressing legal representatives when he says that he wasn't sure whether counsel were trying to bamboozle the judge by those repeated requests, but certainly would be forgiven for feeling bamboozled. It might be helpful to look into the grounds the local authority was seeking after this decision was handed down, or rather, my apologies, when they were seeking their findings to be made. Firstly, that all injuries suffered by the child were the consequence of a lack of care by the father, and that was not supported by expert medical opinion, that medical records and expert evidence didn't support the findings made, that the father hadn't intended to cause injury to the child, and the judge had failed to sufficiently consider whether the father would have caused each injury suffered by the child. And finally, the finding that the mother was unaware that the father had injured the child on a specific event and therefore not colluded with the father. It'd be helpful to look at some of the guidance that was set out by Lord Justice Baker in terms of clarification of reasons. Firstly, he notes that it may take time for any of the messages that are made in reported cases generally to reach those at the centre of those cases and to get through to the general public as a consequence. But he says it's high time they did. And this case is a key example of how that procedure, in his view, is still being widely misused. It's quite helpful that that judgment sets out a list of key points to keep in mind as to what really should be at the heart of seeking clarification of reasons. And we've set them out in a list here on the slide, as you can see, which hopefully will be a helpful key to considering whether that clarification should be sought in the first place. So as you can see from that starting point at the beginning of that list, a focus should be placed really on the omissions and the deficiencies. Where there's either of those or an ambiguity in the judgment and its reasoning, it's at that point that clarification needs to be sought. The judgment doesn't have as an overall aim to address every single point that's arisen within the case. And particularly within care proceedings, the focus should be on whether the threshold criteria has been met, and if so, what orders need to be made to meet the child's welfare needs. Further, when you're making a request for clarification, it needs to be material to the decisions that have to be taken, and you need to be able to identify why that's material. So that's the second point, and directly connected to the second, This shouldn't be used as an opportunity to re-argue the case, to reiterate your submissions, or as some of the judges considered had been the case here, to re-evaluate the findings. Requests for clarifications should not be separate. They don't need to be separately sent by parties, but rather it needs to be a unanimous document compiled by all advocates. And if necessary, there needs to be an advocates meeting to compile that document. It should only be in exceptional circumstances that there are repeated requests for clarifications. It should never be the norm. And finally, judges only need to respond to requests that are material to the case. That means that the purpose of the clarification process is to head off unnecessary appeals. And rather recently, it's had the opposite effect. So what lessons are there to be learned from this case? Not only the ones that are outlined within the 5 points we've made on the slide, but together with that, the consideration of the scope of the hearing altogether. And ancillary to that point is a separate case, which you'll find outlined within a follow-up slide coming up here. And that's the case of GP and Q, another care proceedings case, another Court of Appeal case, which in turn decided to dwell on not only the application of directions and principles that are applied in the criminal jurisdiction to family cases, but together with that considered clarification of reasons. And here there's a focus on 3 separate points that are general points. And again, it's Lord Justice Baker within the Court of Appeal that focuses on what those should be. As you can see on the left-hand side within that table, those 3 primary points are general points that relate to the case overall. So again, we're not looking within that clarification of reasons as advocates to revisit matters, but we should highlight matters that are entirely relevant to a welfare assessment. One point that was rightly made by the Court of Appeal was that the judgment in this case, whilst it manifestly met the required standard, also rightly reflected on the point that all parties invariably are going to be able to point to parts of the evidence that are the evidence they rely upon, and that evidence is not expressly referred to within the judgment. But the wider an evidential canvas and the wider series of facts, it's more likely that that same canvas, that same set of facts, that same evidence the parties have relied upon may be omitted by any evidential argument. That's not to say it hasn't been considered. That's particularly difficult within care proceedings. There needs to be at least one explanation for the widespread practice in care proceedings of seeking clarification. That doesn't mean that every single point raised within proceedings should be detailed and reasoned throughout within a judgment. And finally, where clarifications are used to invite a judge to review findings, that's plainly beyond what is permitted within the request itself. We've discussed this in the case of the previous example, but it's very much not the case that judges that sit in the family jurisdiction that are burdened after delivering judgment should continue to be burdened so by requests from advocates, considering whether a singular piece of evidence has been taken into account, and if so, whether or not that would change the findings they've made. Together with this reasoning that was applied to the clarification process, this case is also very helpful in considering how different areas of law may apply to the family arena that is considered here as directly parallel to criminal matters, and specifically within the reflection of Lord Justice Baker, stemming directly from a separate case, Rian. There's a distinction here that's set out between family and criminal procedures, and that's specifically by outlining the following. Firstly, that they serve different purposes. Where fact-find investigation concerns the future welfare of children in the family court, it's entirely different to that which is applicable to the prosecution by the state of an individual that finds itself before the criminal court. Secondly, the primary purpose of the family court process is to determine what has gone on in the past and to ensure that those findings made may inform an ultimate welfare evaluation as to the child's future. Criminal law concepts, such as elements that are needed to establish guilt or defence, shouldn't have relevance nor function within the process of the fact-finding the family court. And as such, it's fundamentally wrong for the family court to be drawn into an analysis the factual evidence and proceedings that relates to the welfare of children based upon criminal law principles and concepts. Equally, those rules that are given to juries about delay and a defendant's good character apply. An addition that was made within this case is the meaning of good character has been a matter of extensive consideration in case law. But the emphasis is made in civil and family cases, the focus shouldn't be and isn't on whether the prosecution have proved to the criminal standard that a person has committed an offence, but rather it's simply whether the facts that are relevant to the issue in the proceedings have been proved on what is the civil balance of probabilities. The child's welfare remains the paramount consideration. The court needs to require any regard to any harm to have been suffered by the child. Within fact-finding hearings, the judge may well have heard a great deal of evidence about the character of parents and other family members, and that evidence may well include the fact that an individual has no relevant previous convictions. But ultimately, the judge is not obliged to give a formal direction about that, and it just makes up, once again, part of that wide evidential canvas that judges are required to take into account. And it's on that basis that appeals within this case were dismissed. That brings us on to a separate topic within our presentation today, which is the landmark judgment of Rio, a case that deals with non-contact sexual abuse amounting to sexual abuse under the Children Act. This is an appeal brought by the mother in a case where a child was subjected to a repeated exposure to both adult sexual material and nudity throughout the negligent actions of both parents. The father admitted habitually storing pornography and using O's smartphone to store images that were of a sexual nature. The mother, who lived with her own partner, had generated and posted their own sexual images and videos online. The local authority, when refining its case, sought to assert that this conduct amounted to sexual abuse, and it was likely perpetrated by the father. During the proceedings, one of the concerns the local authority had raised was that the child displayed sexualized behavior and had produced over 100 intimate images of herself. The court found ultimately that the parents had neglected O by failing to safeguard her from their adult sexual activity and leading to significant emotional harm and impressionable confusion. The court had to navigate a wealth of material in making its decision in this appeal. Its starting point was a definition within Section 31(9) of the Children Act as to ill treatment and the impairment of health and development amounting to part of the harm definition. It included within that context exposure to sexual material. Together with that starting point of a definition, the court further evaluated the Department of Working Education guidance on statutory guidance on sexual assault and the NSPCC definition. It ultimately found that in reasoning over non-contact sexual abuse, both materials supported that sexual activities would fall within that camp. Statutory guidance was further given by the cases of Re P and Re R, which caution against the use of criminal law labels. The outcome of this case was that the appeal made by the mother was dismissed. The court supported the lower court's classification of the parent's conduct as sexual abuse, refuting any need for intention or active persuasion by an adult perpetrator before abuse can be deemed to occur. Further, and crucially, it validated the use of the term as defined by the statute, judicially recognising the exceptional presence of sexual abuse within the Children Act 1989. And finally, the court also rejected a further claim made by the mother, that is, an unfairness claim against the judge's reliance upon the NSPCC guidance. This was used post-judgment as a further clarification for the findings, and it didn't engage the requirement for the judge to give the parties a further opportunity to comment. And that brings us on to the topic of intermediaries in the family court, which Amanda will explore.
I should have said at the start that we selected these at random, although intermediaries is something that I'm particularly interested in. It's a hot topic, and that's why we're looking at that today. Because I don't know about everyone else, but my personal experience recently is the courts have grasped Mrs. Justice Leven's decision and taken it to mean that we shouldn't have intermediaries in whole trials whatsoever. And in fact, I had a judge saying that we weren't going to do that without even having an intermediary assessment before her or any other assessment before her. And I think we need to be really careful as to how we approach this, because that's not what her decision says. It bears careful reading, because what she sets out in those particular circumstances where it was a deaf intermediary, of whom I think there was only one in the country, for a deaf client with deaf sign language, two signers, and Mrs. Justice Levin runs through the law, which I've set out with the legal framework, section 3A of the family practice rules. But there's no real guidance about the appointment at paragraph 42 of her judgment. She goes on to, there's no further guidance within the family justice rules as to how and when and whereby they should be appointed. And on the right-hand side of the slide, what's set out there is the sort of nub of, or the heart of her judgment. But I think the key point of that is that all advocates have to be familiar with the vulnerable witness toolkit. They should have done the vulnerable witness training, ideally. They need to be referring to that in their advocacy, and to the guidance that's provided by any intermediary assessment. The first step was that we need to simplify our language. We need to be very careful, because it's very easy to slip into bad habits about using colloquialisms. I'm particularly bad at that. And bearing in mind the audience is all the audience behind us, not just the judge in front of us, which sometimes I think we can lose sight of. So it's our duty to break it down the process to our clients. And ultimately, it's a decision for the judge. So she will have submissions. All parties may agree that there needs to be an intermediary, and there needs to be an intermediary for a whole trial. But ultimately, it's a decision for the judge to make. And the test is not because it'll make the hearing easier. But she does, in that judgment, go into, and I'm just bringing it up, the other leading cases, which are particularly criminal law cases, where they don't have, or it's incredibly rare to have intermediaries for the whole trial. And she makes that comparison within her judgment. But as I say, ultimately, she went on to order a deaf intermediary for a whole trial in those particular circumstances. And then we have, I think, hopefully on the next slide, that is a decision by Judge Middleton Roy, and he also made a whole trial order for an intermediary. Again, he was very careful to limit it to the particular circumstances in that case. But, and this is my commentary, my concern is that there's this seems to be this general trend towards rowing back the support of intermediaries for whole trials, just to have them for when your client gives evidence. How can we be certain that they've understood? So it's not just about us using common language, avoiding colloquialisms, doing everything that the toolkit says we should do. It's having the time to sense check as you're dealing with all the papers and all the case and all the other submissions that are coming at you and the evidence that's coming at you, you having the time to do that, to sense check it. And that's my fear, that it's all very well saying, well, we need to use the toolkit, but it's the time limit that we've got, all the pressures of the courtroom to constantly be checking that our clients keeping a pace with the evidence. And that's where an intermediary fulfills a role that, arguably lawyers don't have the skills to fill that gap. And the cynic in me, I think Carolina helpfully put some picture of money on there. The cynic in me wonders whether this is a cost-saving exercise by HMCTS, but I couldn't possibly say anything more on that. But also whether it's a breach of Article 6 not to have an intermediary, not to understand that the proceedings are ongoing and not having a comprehensive understanding. But of course, they're not doing it in the criminal courts. They're not having whole trial intermediaries. And there doesn't seem to be a raft of Article 6 applications and appeals in the criminal proceedings. So maybe if you were to bring an argument and appeal on that basis, would you be successful? I don't know. But I just have a note of caution. I was rather taken aback by a judge making a decision that we weren't going to have a whole trial intermediary without any assessments. How can you make that decision without doing so on a factual basis of knowing what support they need, what the alternatives are for an intermediary providing that, and to make a reasoned judgment in relation to that. I think that was all I had to say on that. Did I have anything else? No, that's you next.
No, that's me. Moving on to another hot topic, which is that of the FDAC model and whether that should be something that's used more widely. And the starting point for this topic being explored more widely more recently, and the President commenting on whether that should be available really within all courts, is this case that you can see referred to on the slide, the case of the London Borough of A versus A, B, C and D. C and D being the children before District Judge Hewen. It's a February 2024 case relating to two brothers with the age of 8 and 5. And interestingly enough, it was deemed from the very beginning of proceedings being issued that it would be a case suitable to conduct within the Family Drug and Alcohol Court, also known as FDAC, as you can see the acronym on the side. It was an unusual case to be allocated to the FDAC court, as it didn't really have issues in relation to substance misuse. The primary concerns within this case for the judge and indeed the local authority were related solely to domestic abuse and neglect. But it's an important reflection on whether actually using the FDAC model can help parents to engage with the court process more effectively and indeed help cases resolve far more successfully. And it does bring on perhaps a reflection as to whether we should recognise more widely that cases can be more successful and can indeed benefit from this model, whether or not substance misuse is a core issue. This is one such case. In this case, Children's Services had had a long-standing involvement with the family due to reports of domestic abuse. The older of the two boys had been subject to a child protection plan for most of his life, and domestic violence was accepted by both parents as having been a live issue between them, and indeed having been witnessed by the children on various occasions. The children were also exposed to neglect, and as a direct result of the conflict between parties, they had been taken into care. However, to the credit of the local authority in this case, they were signed up to FDAC. And by the time of the first hearing, the local authority not only had deemed the case suitable for FDAC, but had liaised with the clinical lead who had confirmed they could accommodate the case. Now, the process is a rather formulaic one. However, it's plain that the FDAC model has been able to benefit the family in this case, much like in many other cases, precisely because of the intensive nature of the work it offers. It's important to reflect on the multidisciplinary aspect that FDAC can provide parents with. There's a series of groups and resources and access to various support groups, key work sessions with the parents that simply aren't routinely available to parents within the standard care proceedings model. But in this case, they really greatly assisted the mother to the extent that there was a reunification with the children and they were left under an interim supervision plan as opposed to in foster care. There's much to comment on the outcome of this case, and the judge does so in a postscriptum, which is particularly helpful. His reflections on the FDAC programme is that it's, as I've mentioned, the intensive nature that helps the parents work towards it. But crucially, it's a dynamic and it's an ongoing assessment rather than a snapshot assessment. Really what FDAC is doing is it's supporting parents and watching them respond to that support, respond to interventions. And with that consistent and intense nature of the support offered, it's able to also engage the parents more adequately, and it's able to gain their trust. Likewise, the parents are more engaged in the court process. As you've seen from some of the statistics on the left-hand side, it's very positive that some of the outcomes from surveys relied upon within the second annual report on FDACs by the President include that as high a percentage as 57% of parents completed the FDAC programme altogether. That really does reflect a consistent engagement, and one that then hand in hand with that engagement brings on positive results. As you can see, 53% of parents go on to reduce or cease alcohol use, and 45% of children are returned to live with their family. It's a very important reflection to have, together with the effectiveness of the FDAC model, how widely that really can be used. Currently, we have 37 local authorities that are served by the FDAC model, and 13 of those fall under the Pan-London FDAC. And the President's invitation for the FDAC programme to be extended to all local authorities are reflected within his annual report, and indeed supported by these statistics. However, is there something to be said for some of the effects this might have on local authorities as well? It could be cost effective, and in that sense, there might be cashable savings for local authority. It would also help them to engage more effectively with parents, and indeed it would increase the likelihood of a family placement as opposed to care in the local authority. It's clear that all of these positive outcomes are supported not just by the statistics you've seen here relied upon in that report, but also from independent resources such as the Centre for Social Justice. And again, we'll be able to include those statistics and a link to the same within a subsequent handout. But together with that, it's important not just how successful the process is, but I would say how much trust it gives the parents that are engaging in these proceedings with the court process as a whole altogether. They report not only being more likely to become abstinent, but actually viewing the process as more fair. They're more likely to find FDAC judges supportive, respectful, and they value an opportunity for direct engagement. There's really reason to believe, according to the Centre for Social Justice, that actually, although we're awaiting the empirical evidence, FDAC support systems are more likely to also reduce the occurrence of domestic abuse. So perhaps this is something that should be considered on a wider level. That said, how manageable is it to really be able to extend this on a wider network? My experience of the FDAC courts is that they very much are tailored to particularly difficult parents in terms of their substance misuse. And reading a judgment like this, where the focus of the local authority is one of domestic violence, certainly is a standout case. And I'm sure Amanda's experience will also reflect the same, in that this is very much a model that's focused on that particular concern. And with local authorities already being overstretched in terms of their resources, this may be something they might want to consider moving forward where accessible.
Now, there's one question that's come up about FDAC. I don't know whether you want to take that now or look at it later in terms of costings.
Well, I think that does tie into one of the points that we've raised, really, which is exactly that. How manageable is that for a local authority when there is such a high cost associated to it? I think we can come back to that question, perhaps address it in more depth, but that's an important one to reflect on, because it's really the reality of what most local authorities are squarely facing when considering which arena is best to consider individual cases within.
I think it's difficult if you just look at the cost of the FDAC proceedings in and of themselves, because it ignores the other costs, not just societal costs, but the fact that if you make significant change within the FDAC process, you may then not have another set of care proceedings in relation to the same family and all the costs that that entails, notwithstanding, as I say, the benefits to society of having children being brought up in their families. It ignores the cost of foster care. So it's, I would say, cheaper in the long run. Money well spent, unfortunately not spent enough. Yeah. The difficulty is on whose budget does it land, and that's always been the tension. This is quite a brief topic, joinder of medical professionals, and I think it's very fact specific, but I just thought it was quite interesting. It was about a case where it was the court was looking at fabricated medical conditions and exaggeration of medical conditions of 2 children. There was a Dr. K, who is an expert instructed within the proceedings, and it appeared that she became overly friendly and developed an unprofessional relationship with the mother, which impacted on her medical opinions. I think that's probably as significant an allegation as you could make to an expert within proceedings. And unfortunately, the issues really arose as they were going through the fact-finding part of a final part of a hearing, with having heard 4 weeks of complex medical evidence. And as they were hearing oral evidence, having initially started the proceedings saying there is an issue, but we're not seeking findings against Dr. K. As the evidence went on, it appeared that they were going to have to seek findings against Dr. K, and how that would be dealt with by the court, and whether Dr. K should be a party to those proceedings. And it was submitted that by making her a party or an intervener, that would have a significant impact and lead to delay. And the court felt that because she'd had access to some of the papers that were relevant to her, that was sufficient to protect her Article 6 and Article 8 rights, and recognising that the GMC would probably be looking at this case fairly closely. But just a reminder, looking back at the President's working group on experts, they made recommendations in 2020 to support the experts, the limited pool of experts that we are using, because they do take criticism to heart. It limits our pool of experts, so it's how we can look at better training, and it's all set out within the working group guidance recommendations that you can look at. I don't think we've put the link in there, but a reminder of what's set out there, which is an online checklist to standardise expertise, increased awareness of existing training, improving collaborative working between the various royal colleges, medical colleges to cooperate with trusts and commissioners, to have conversations about the court process, to get more experts involved in giving us reports, because there's always a difficulty with having a small pool of experts. Looking at commissioning arrangements, because the payments, how they're paid, how often they're paid, how late they're paid, how much they're paid, those are all issues that narrow our pool. Judges being prepared to remove cases from the 26-week track where there's a number of experts, because it's a recognition that obviously the case is complex and it's probably not going to be achieved within 26 weeks. Well, that's tiny. Sorry.
It's tiny. We thought we'd rather maximise the size of that font.
My apologies. It will come out bigger in the wash. Prior authority, Part 25 adherence, cross-examination training for these experts with the assistance of legal professionals, the appropriateness of judicial criticism to be balanced. If a critique is if it becomes obvious that there's going to be a criticism of an expert, they need to be given notice, detailed notice by way of a position statement or a skeleton argument, potentially supplementary questions. Almost it's a right for them to be heard and to argue or to gainsay any of those criticisms. Copies of the judgment to be sent to the experts. That's in the practice direction. It never happens. No one ever remembers. It's one of those things that we need to be better at remembering. Looking at the FLBA reviewing their training, information packs, regional experts and committees being gathered together. And so looking at better ways of working and using those experts that we have, but also hopefully making it a user-friendly environment where we can get more experts involved in these proceedings. I think that's it.
I think that is it, yes.
Right, next slide.
That brings us on to another topic that you may well have seen splashed all over the media recently in light of the new amendment that's being made to the Victim and Prisoners Bill. This was previously, I would say, covered rather extensively in the past couple of years because of the case of Jade Ward, which I'll come on to shortly. But effectively it builds onto a law named after a woman who was victim of murder and left behind children. and sparked a conversation as to how parental responsibility should work and should look like on the ground, where one parent has effectively been found guilty of murdering the other, or indeed found guilty of voluntary manslaughter. Now, the previous amendment had been simply to consider apologies, I've lost my train of thought. I'm just considering what the first stage was before we got to the amendment. I'm thinking of the tabling to the Criminal Justice Bill, which I'll come on to shortly. But the starting point really here is that the Criminal Justice Bill was most recently reviewed in the last couple of weeks on the 10th of May. And together with a range of other criminal matters, looked at the suspension of parental responsibility. Where there is, as I've mentioned, a parent who is convicted of murder or manslaughter of the other parent, there should be an automatic suspension of parental responsibility, with exemptions to only apply where there are cases of domestic abuse. And because of this, families of the deceased will no longer have to apply to suspend or remove parental responsibility. We are all familiar with how parental responsibility arises and who can or cannot have parental responsibility. But perhaps it's important to have a moment to reflect on what previously the landscape legally was in terms of how a parent could lose parental responsibility. A case such as that of Jade Ward was one where parental responsibility for all women in her position, or indeed any parent who'd been a victim of murder or manslaughter, would not have led directly to a loss of parental responsibility. And what that means is that that parental responsibility continues to remain live unless the child is adopted. Short of adoption, the court has no power to remove responsibility from the leftover parent of the couple. And understandably, that will cause distress to the family members that are left to deal with the welfare of the children and consider what that means in relation to the involvement of the other parent. Practically, what that looks like is things such as consultation about which schools the children should go to, medical treatment, the right to access medical treatment and educational records, and permission to take the children abroad on holiday. The fact that parental responsibility cannot be removed doesn't mean it can't be limited. And this is rather a drastic step, in my view, from... that's a good question. I think one will have to come back to, because that will have to be something that is considered, hopefully, by whoever takes the victory in July. But looking at the removal of parental responsibility as is proposed from this criminal justice bill stems really from what was, as I was outlining, the legal landscape we had beforehand. So the argument that's made really from this case that sparked this debate is that that's an onerous process. It shouldn't have to be done by the family. It shouldn't have to be such a time-consuming and expensive process. And furthermore, it should be possible to go to court just once to obtain an order that limits all exercise of parental responsibility. So effectively, that would mean that if the parent still had PR, they could not use it for any purpose. Now, the proposal really with the suspension of parental responsibility is that that involvement ceases altogether. There's a discussion to be had as to whether that's something that is either a reaction that has been sparked by this individual case, which has been widely reported in the media and understandably caused an emotional response from people becoming aware of the details of the case. Is it something that goes too far in terms of the involvement of a child with a parent that's had their guilt proven by a criminal court and been found guilty to have removed a previously crucial part of their life from them? What other remedies could there be? Is it the case that perhaps limiting the extension of parental responsibility rather than taking that drastic step of altogether suspension might be able to benefit children more widely? It's something that's rather difficult to discuss without having watched it come into action quite yet, but my view is that this is perhaps something that seems to be a reaction to this individual case. And whilst I wouldn't go as far as saying it's something that's a drastic step, I do think other remedies should be taken into account, and we should have view of what those are to consider whether parents' involvement could actually continue to be beneficial and whether there might be a way to involve them in a way that doesn't necessarily require direct involvement of family members as well. That might look like involving third parties, and that's not always straightforward. But it certainly is the case that where that involvement benefits the child, it should be continued to be considered. I don't know if, Amanda, you had any views on that.
Well, I'm just wondering about the psychological, it's not a legal argument, but a psychological argument of cutting a parent out of a child's life, even though they may have done this heinous act. You run the risk of them being demonized or in an unhelpful way in the child's mind. So, and there may be an argument for ongoing contact, even though this parent has done this heinous thing. So I just, it seems a bit like a sledgehammer to crack a nut, to use the phrase. And as you rightly point out, section 9114 is available. There are other options. Is it right? I don't know. That's perhaps a philosophical discussion rather than a legal one. Now the ALC have just posted this evening at 7:10 the link to the speeches, or one of the speeches that I'm going to talk about in looking at adoption and revocation of adoption orders, but in particular adoption, because it seems to be looking at the President's two recent speeches, which I've set out there, one of his hot topics, rightly so. I think the adoption process is long due for an overhaul. But looking at the two cases, one case set out there anyway, Re X and Y. This was again a judgment of Mrs. Justice Leven looking at the court's power to revoke adoption orders. This was quite a sad case where the children were of an age where they had a relationship with their parent when they were placed for adoption. There was a breakdown in the adoptive placement, even though their adoptive mother had taken in the biological mother to live with her and her two children, which is quite an extraordinary step, but was trying, I think, reading between the lines, to do everything to shore up that placement of the children when they were reaching those difficult teenage years, which are the key years for adoption breakdown. Anyway, it all fell apart. The children went to live with their adoptive mother, and both the children who were 16 and 17 and went to live with their biological mother. The children went to live with her. They applied to revoke the adoption order. The adoptive mother was part of that application. She supported the revocation, and Leven said no, in short. The court's power didn't extend to revoking an adoption order on welfare grounds, even in cases of exceptional circumstances. I'll come back to the President's speech because I then, helpfully one of my colleagues in Chambers said, actually, there is an exceptional circumstance case, which was quite a sad case about I don't know, is it on there? Sorry. No, it's on that. No, I can't go back. No, I can go back. A case where a young person was placed for adoption, and her adoptive parents sent her to live with their family overseas, who abused her. As an adult, or nearly adult, she returned to this jurisdiction and successfully applied to have an adoption order set aside. That was a 2015 case, and I think we'll come to, and if I haven't, I can put it in the handout, the references for that. So I think it depends on the circumstances, although Leven may say the court doesn't have the power. In those exceptional circumstances, the court found that they did have that power. But the reason that I sort of put the President's speeches there, the Mayflower speech, he sets out the legal framework in relation to adoption, so it's quite a useful reminder if you're wanting to look at the legal framework. But he looks at a lot of research in no particular order, and it's quite interesting, the research that he looks at. And it very much seems to be a flow towards having contact, if it's safe to do so, post-adoption. And it talks, all the research looks at all the benefits for children in doing that, and why we should be looking at that as practitioners, and why we should be challenging, or I certainly do, challenge this notion that it has to be closed and the adopters won't accept it. It's about better training, because the benefits to children, given the the lives that we now all lead in the world of social media, it is unrealistic to expect that a closed adoption will stay a closed adoption, because children will go online, and they're going online at younger and younger ages, and it's leading to breakdown. So, what all this research has been looking at is, should we have open adoptions? If we're going to have them, what does that look like? How could we modernize closed adoptions? Should we be looking at different systems? Because some parents aren't keeping up with the letterbox contact. Could we look at, and there was a trial run by, I think it was East Anglia University or Anglia Ruscombe University, looking at electronic means of letterbox contact, for want of a better phrase. And it was difficult for, if I use the expression, care clients to consistently engage in electronic contact, letterbox contact. They didn't have the means, they may not have had the wherewithal to do that. So it was a trial, and it wasn't, I think it had mixed success, if I put it that way. The President also looks at the Public Law Working Group on Adoption, and looking at the evidence, as I say, about transparency and openness. It also considers the benefits, because when we're saying letterbox contact, we're generally only talking about a parent, an immediate parent, and the benefits to a child of maintaining a relationship, even if it's not with that parent, but with the wider family network, with siblings. They often, I don't want to say forgotten about, but lower on the priority list when we're looking at finalising proceedings with care orders and placement orders. But the benefits to these children of having that contact. It also talks about Northern Ireland and the shift in the process there, and how that's brought about a change in their processes and the outcomes for children that are placed for adoption. And then in his potato conference, which, for those of you who don't know, potato stands for, I'm not making it up, Parents of Traumatised Adopted Teens Organisation, which is a group of parents, a support network for adoptive parents. And they look at, and again, he was giving a speech to them, and he looks within that speech at yet more research, which looks at contact, something I didn't know. In New South Wales and Australia, the default position in New South Wales is for there to be ongoing birth contact with parents. And that hasn't led to a decrease in adoptive placements, it's actually led to an increase in adoptive placements. I can't read all of that question that's just popped up, but it'll come through. So what some of the research was saying is, where adoptive children had positive relationships with parents, grandparents, or siblings before adoption, that sense of loss, of being cut out, is traumatic. But staying in touch with siblings and grandparents is less emotionally complex than contact with parents, and contact with these birth family members is often lasting and rewarding.
There's the question in its entirety.
Okay, I'll come back to that. So there is the final report of the Public Law Working Group Adoption Subgroup, can he names these, that's due later this year. But, and I'll come to the question, but I do think it seems to suggest a change in approach. The question, I attended a recent Adopt England webinar. There was a question as to if a family should be approved as adopters if they cannot support contact with birth families. I think it all depends on the circumstances. You've got to look at it, but I think the starting point has to be that there should be contact, if it's safe to do so. It has to be safe to do so, for the child and for the adopters. But this idea that our starting point has always been that we can't do that, it's too difficult, it'll break down the adoption. We need to shift that mindset towards, and completely turn it on its head, frankly. I'll leave to you next.
Yes. Moving on now to a DoLS case update. I'm going to start with our case on the left, which involved one of our very own members of Chambers, Christy Scarborough, acting for Peterborough City Council. This is an application by the local authority for a deprivation of liberty order, which you may have seen reported across broadcast media and specifically in BBC News, where there was a rather detailed article outlining the circumstances of the case. And it deals with a child, SM, a 12-year-old child with profound and enduring disabilities. Mrs. Justice Leven here provides an important judgment that raises an issue. That issue specifically being whether such an order, a deprivation of liberty order, is required in the case of a child as severely disabled as SM. And it's important to understand what SM's condition was in reading this judgment, because the severely disabled description that we're seeing in most of the media reportings doesn't quite go into this amount of detail that really is required in understanding why the deprivation of liberty safeguards were actually applied in this case. So for context, SM's only body control was being able to move her hands away and to wriggle and roll from side to side, which people that knew her, she was reported to enjoy. Those who knew her well were able to understand whether she was responding negatively or positively to any stimuli. She was in the care of carers who could meet her every need, and they provided her with a high quality of care. She was made subject of a care order in 2022 and resided with foster carers. Case was heard in the High Court initially and then allocated before Mrs. Justice Leven, who heard the restrictions sought by the local authority as follows: that she be supervised on a one-to-one basis in the home, either by someone who was physically present or by a remote live video feed, that she was moved as appeared to be in touch with her welfare needs, or as necessary to meet her welfare needs, that she was met with a feeding and administration of medicine tube managed by her carers, again, as necessary meeting her welfare needs, that she be dressed, undressed, washed, and have any of her incontinence needs managed, that her bed be fitted with bars to prevent her moving in bed and avoid any injury, that she continue to be supported outside of the home at all times with 2-on-1 supervision, and that the property of her home should be kept locked for the purpose of ensuring that she was kept securely within the home. Together with the issue of whether SM should actually become subject to a DoLS order, the court considered a series of aspects of the required restrictions, which it felt did not amount to deprivation of liberty. The first 5, which I've outlined, effectively made up her care plan, and these weren't actions that deprived her of her liberty. That would be the case whether or not SM had been severely disabled. There were also a series of aspects in her care that, in Mrs. Justice Leven's judgment, she felt should be considered as to whether they would be an intrusion on her Article 8 rights, her being SM. And here we come really to the crucial part of this judgment, which is the consideration of whether or not SM's Article 5 rights, that is her right to liberty and security, were in any way being fettered. So the local authority's argument was that SM couldn't consent to her own confinement and that she wasn't free to leave, being subject to continuous supervision and control. In that sense, she met what is known as the Cheshire West test. The court, however, concluded that the local authority's application takes those principles and makes an extreme conclusion in that it defies common sense. So the question that really Mrs. Justice Leven was grappling with here was whether or not there needs to always be a fact-specific consideration when there is an individual deprived of their liberty. Cheshire West, in the facts of the case, which again we'll include a link to within the handout after this talk, doesn't deal with a child or indeed a situation where the disabilities that are crucial to this case are mirrored by the facts of that case. SM was a child who was incapable of leaving her property and had a combination of physical and mental disabilities that were inherently part of her personhood. They weren't by any reason of the restraints placed on her. And the reason why she could not leave where she was living, again, was down to those profound disabilities and not by any action of the state by restraining her or failing to meet a positive obligation to enable her to leave. So, on a conceptual level, as is reflected upon in the judgment, it's actually rather difficult to see how someone in SM's condition could be deprived of something she's incapable of doing. But then equally, how could she be deprived of a right that she's incapable of exercising? The court effectively found that whilst there is an acknowledgement that a deprivation of liberty here may apply in abstract to a disabled person who cannot move and cannot leave the property without assistance, that would put the state under an obligation to assist a person. Failure to do so might amount to a breach of Article 5. And that's the Cheshire West situation. However, that situation is entirely separate from that of SM. SM is both physically incapable of exercising her right to liberty in Mrs. Justice Leaven's judgment, and she's mentally incapable of asserting it. And as such, it was not the case that the local authority's argument, which was that lawfully authorised restrictions should not be enabled in the case of SM, amounted to the case of Cheshire West. The argument that was made was that as a 12-year-old, this was a very separate circumstance from any other 12-year-old in her position. An ordinary 12-year-old, the local authority set out, would be able to come and go as they pleased and leave a home of their own will. But Mrs. Justice Leaven ultimately disagreed. She concluded that SM in this case was not being deprived of her right to liberty under the terms of the human rights legislation. And to compare SM to a non-disabled 12-year-old as an objective analysis was, in her words, a wholly unreal exercise. However, this does remain an important case about the requirement of such an order in the case of children who are severely disabled. The second case that we're looking at within our DoLS update is the case of...
3 minutes.
We've got 3 minutes. I'll try and give you a whistle-stop tour of this case. It's the case of Ryu. The local authority here applied again for a DoLS under the inherent jurisdiction, and you was a 7-year-old child with diagnoses of autism and ADHD. You was placed in a children's home under an ICO, an interim care order, due to being a risk to both themselves and to others around them. There were a series of incidents of concern. These included physical attacks that led to restraint, the throwing of objects, damage to property, and ultimately the combination of these led to the requirement of a one-on-one adult supervision on a 24/7 basis and 2-1 within the community. The Guardian in this case made a Part 25 application for an independent psychologist to consider the harm that the restraint might have upon you, whether there were more effective methods of behaviour management, and indeed whether the placement was the right one for you. And the court shared the Guardian's concerns, granting that application. So the court had to ask itself 2 questions in considering the local authority's application. Firstly, did those arrangements amount to a deprivation of liberty? And if so, was it in Yu's best interest? Ultimately, the court, having considered Yu's rights, determined that the conditions that the local authority was considering as justifying the deprivation of her liberty were met. And that was because at present, there were limited realistic options for you to be able to prevent risk of harm to themselves and others. And on the evidence available, it was in their best interest to make an order depriving them of their liberty. That would only be permitted, however, for a short period so that was, I believe, a month, when the matter would then be subject or further review by the court. And that would then be a hearing where the court thought it would be appropriate to reconsider the assessment of an independent psychologist to be filed ahead of that hearing. So again, an interesting case to try and understand the specifics of whether acts of restraint are suitable in cases where indeed there might be consideration of more effective methods of behaviour management, and consideration again of whether the placement is adequately tailored for the individual at the centre of it. And that brings me to the end of our DoLS case update.
Now I'm conscious of the time, so I'm just going to show you that slide, tantalise you with the ick factor. It really is ick. But I thought it was interesting because the local authority made an application for parent testing to determine parenthood of the father, where the father and his father had mixed their sperm together. And it was refused because effectively they didn't have sufficient interest in accordance with Section 55A of the Family Law Act 1986. And I've just queried there whether the guardian would have had sufficient interest. Would it have been a different outcome if there'd been an ICO rather than an ISO? But if you want to be grossed out, then look that case out. On that note, conscious of the time, thank you very much for attending. Any unanswered questions will follow up by email. The recording will be available shortly from our lovely Sophie Hicks, who manages all these things. And the next webinar in the series is on the 13th of June, and that is George Butler, joined by Ben Lasky, who's a chartered psychologist. And they're going to be discussing when proceedings commence because a child is beyond parental control, to what extent is it necessary or helpful to pursue, in addition to threshold findings, that a child has also suffered significant harm as a consequence of the care they have received. Do such findings shift the blame away from the parents and onto the child? I know I have a very firm view on that, so I'll be interested to watch that, and thank you very much for joining.
Thank you.